Hello friends, in the series on the income tax cases, today we will discuss a very important case of the Madras High Court. The date of the judgment is 27th June 2022 and the title of the case is Shrimati PARVEEN AMIN BHATHARA versus Income Tax Officer. This case has been reported in 446 ITR at page number 201. In this case, the notice under section 148 was issued to the assessee. The date on the notice was 31st March 2018 and this matter was related to the assessment year 11-12. See the laziness of the department that for the assessment year 11-12, when the last date is 31st March 2018, on the same date the notice is being prepared and it was issued to the assessee, which was received by the assessee on 18th April 2018. So the dispute was that because in section 148 it is written that if the notice is issued within 6 assessment years. So the question is that whether the issue word involves the service of the notice or not. So there is a lot of interpretation on this, that whether the issue involves the service of notice. If we will go by the section 13 subsection 1 of the Information Technology Act or the Supreme Court judgments, then in the broader sense there is a difference between the issue of the notice and the service of the notice. Issue is complete only when it is the outreach of the department. But in this present case, because there was date on the notice was 31st March 2018 and it was not out from the powers of the department on 31st March 2018. So it cannot be said that the notice is issued on 31st March 2018. The assessee filed the writ petition, but the writ petition was dismissed by saying that according to section 149 subsection 1, if the notice is dated 31st March 2018 and issued, then it doesn't matter that if the notice is received by the assessee after that. But the assessee filed the appeal against the writ order, which was entertained by the Madras High Court by relying on the judgments of the Gujarat High Court and the Allahabad High Court. The famous judgment of the Gujarat High Court is Kannubhai M. Patel HUF versus Hiran Bhatt, and the second judgment is Dauji Abhushan Bhandar Private Limited versus Union of India, which is reported in 444 ITRH page number 41, in which it was held that if the notice is received by the assessee after 31st March, then it is not a valid service of notice, and in which it was held that the date of the notice is not important. It is important that when it comes to the knowledge of the assessee, simply because the notice has been signed, simply because the notice is dated 31st March 2018, then simply it doesn't mean that the assessee has come to the knowledge of the notice. In this case, a lot of literature was discussed, a lot of interpretation was discussed about the issue and service of notice, but it was held that since in the present case the notice was not served on the assessee up to 31st March 2018, because the department was not able to substantiate on the facts of the case that the assessee has been served the notice in the email up to 31st March 2018 at 11:59. Even if the notice is being served or received in the mail of the assessee at 12, even then it will be out of 31st March criteria and the notice will not be valid. Friends, in the earlier time when the notice was being sent by the post, then there was clear law that if the assessing officer has sent the notice to the postal authorities and it is out of the control of the assessing officer, only then it will be termed as issued and served. But when the technology is being used and when the notices are being sent by mail, then until and unless it is received by the assessee on the email ID up to 31st March, it cannot be said that the notice is being served on the assessee within the time limits. So friends, this case is very important as far as the litigation under section 148 is concerned regarding the issue and service of notice. This is a landmark judgment. In this case, the Madras High Court in the earlier judgment, 3 months earlier judgment, the Madras High Court has given a different verdict, but because this judgment has come after that, so according to me, this judgment has more weightage. At the end of this video, once again, I am repeating the name of the case. The name of the case is Shrimati PARVEEN AMIN BHATHARA versus Income Tax Officer, and this case has been reported in 446 ITR, page number 201. Thank you, friends.